Hello, everybody, and thank you for joining me on this beautiful Friday for what amounts to a bit of an impromptu case law update. I wanted to get this out before the weekend. As many of you know, yesterday, the Florida Supreme Court issued its decision in Dial versus Calusa Palms. This, of course, was the case that had been pending review on a certified question from the Second District Court of Appeal. And the question was pretty simple. Does the analysis and holding of Jorg, the 2015 case that held that evidence of collateral benefits as applied to future medical expenses is inadmissible, does that apply to past medical expenses? And the answer by the majority of the court was no. Now, there is a singular dissenting opinion by Justice Labarga, who does talk about footnote 7 from Jorg, which said back then we don't see a difference, a factual difference between future and past medical expenses. But a majority of the court felt differently yesterday when they issued their opinion. And what's the takeaway here for practitioners? Well, it's pretty simple. If you represent a plaintiff who received certain medical care in the past, and let's say the care billed was $100,000, if he or she received the benefit of Medicare and the amount left owed is only $10,000, then the jury is going to hear about that $10,000 number. Now, one aspect of the majority opinion that makes a lot of sense, which is that whereas in future entitlement to Medicare benefits is a bit speculative, it's not speculative at all in the past. He or she either received it or they didn't. But what the majority doesn't really delve deep on, and Justice Labarga does, is it nevertheless invites some prejudice by the jury, because when they start hearing about evidence of collateral benefits, they might be misled to think, hey, if the amount left is only $10,000, then maybe the care wasn't that serious or the injuries weren't that serious. So the takeaway from the Dial opinion is this: Jorg no longer applies to past medical expenses. Those days are done. The footnote 7 from Jorg has kind of been eviscerated in terms of its meaning. And if you are a plaintiff personal injury lawyer out there, you need to be aware of this change, because you may be on the verge of about to try a case or helping your client decide, making an educated decision. Should we take the settlement offer or go to trial? And if your case was really heavily resting on the idea that you could put up to the jury the full amount billed, but now you know that you can't do that, this is something you need to be aware of. So it's a very short opinion by the majority. I think it's very clear what the holding is. And we'll see how this plays out through the trial courts and whether or not there's some gray area in the future. But for now, that's the law. I wanted you to have it before the weekend. And as always, thank you for joining us. Stay tuned for the next podcast, which comes out this Sunday, where we have for our first time a special guest, Keela Smith, our senior trial lawyer. Thank you.